Hearing in the appeal, Queen on the application of Maughan and Her Majesty's Senior Coroner for Oxfordshire.
Mrs. Monaghan.
My lords, my lady, I appear for the appellant with Mr. Bunting. The appellant, as your lordships and your ladyship will have seen, is the brother of the deceased, Mr. James Maughan. Ms. Hewitt appears for the respondent, Her Majesty's Coroner for Oxfordshire. And of course, that was the coroner that conducted the inquest that's the subject of this appeal. Mr. Hoff represents the Chief Coroner, who's been granted permission to intervene to make oral and written submissions. His responsibilities are summarised in Mr. Hoff's case, and Mr. Hoff appeared below in the Court of Appeal to make submissions too. In the ordinary way, my lords and my lady, the Chief Coroner and the Senior Coroner take a neutral position. They have put in written submissions to put the various competing arguments, but they don't take a position themselves. Mr. Straw, who's there, will move forward tomorrow, represents Inquest. Inquest, as you will have seen, is an NGO almost entirely established to assist families in and support families going through the inquest process and campaigning on related issues. There is a small bundle on your bench. I'm afraid that some documents, for some reason, fell out of the printing, and they really are just for completeness, save for one, which I'll take you to. So you have at 2 and 3 some missing documents. 2 concern or are parts of the Broderick report. The MS numbers are included, so you'll know where to slot them in, but they were omitted for reasons that were unclear. I think it was a printing error. And you have the transcript in NUT, which is the case behind tab 39, where there is a summary, but for reasons I'm unclear about, the transcript didn't go in. And then behind tab 1, perhaps more importantly for the purposes of the hearing, you have the position as it applies to Scotland. Mr. Hoff in particular thought that might be helpful for you, so you know that there is a different process in Scotland, and Mr. Hoff may want to raise that with you in due course. So those are the introductory matters. As you all have seen, this appeal proceeds with the permission of the Court of Appeal. It's the first time, so far as any of us are aware, that this issue has come before the courts at this level. 2 issues, as you will have seen. Firstly, the standard of proof in a coroner's court in coming to a conclusion on suicide. And secondly, relatedly, whether or not the answer to that question is affected by the form in which the conclusion takes, whether it's short form or narrative. In short summary, the appellant's case, consistent with the approach adopted over decades in the courts and in the form, which I'll come to shortly, is that the standard of proof is the criminal standard beyond reasonable doubt, and it makes no difference whether that is in short form, suicide, or narrative form. For example, the deceased person deliberately took his or her life intending to kill themselves. So whichever form it takes, we say there can be no principled reason for adopting a different standard, and it's our case that the standard is beyond reasonable doubt.
Is your second issue really an issue, Ms. Monaghan?
It's not an issue for us, because it seems to us that the short form and narrative, yes, my lord, we say there cannot be a principal difference.
But is there any active suggestion to the contrary at this level?
Apart from the neutral positions, that is explaining the context, there isn't a positive suggestion that there should be a different standard of proof, but you'll know that was something that was picked up below because it was said that arguably the form suggests otherwise. We say no, but that was a matter raised below. But certainly here, we don't say it's of any significance, and there isn't a positive case put otherwise by any of the parties.
The form actually states otherwise, doesn't it?
Yes.
I hope you've got a message
We did.
this morning about some authorities, to which I could add there is a discussion in Benyon as well.
We'll make a note of that. Thank you very much. We had a brief look.
Yes, I appreciate it came very late.
Yes, and so far as I can tell, it's helpful to us, but I might be wrong because I haven't studied it closely enough. Maybe I'll regret saying that. But I will come to it perhaps after lunch with your lordship's leave, and we'll look at Benyon as well. I'm grateful. I should say that inquests take a slightly different position, as you will have seen. Inquests say, and they are the only party to address this, that if your lordships and your ladyship are against us and conclude that the standard of proof for suicide is the civil standard, then the standard for unlawful killing should also be the civil standard. We make no submissions on that and say it doesn't necessarily follow at all. But that's a matter for inquests to take up if they choose to do so.
The problem for us, I think, is that if we determine the answer in relation to suicide without saying anything about unlawful killing, that's going to relieve a lacuna.
Well, if your lordships and your ladyship say nothing about unlawful killing, then matters will proceed as they are, and that is that the standard remains the criminal standard. And as Mr. Hoff has said, there are reasons why, even if you were to find against us, and of course I urge you not to, but even if you were to find against us, there are reasons why you may conclude that unlawful killing, murder or manslaughter, in the context of an inquest, where commonly the killer will be readily identifiable, is perhaps...
Yes, the only point I'm making is that we will probably want to consider that also, so that we have dealt with the whole picture.
Well, some of the cases, as your lordship will have seen, are unlawful killing cases anyway, so there's some learning to be had from them in any event.
But will you not want to argue that in terms of consequences, although they're quite different, which is the principal justification for the heightened standard in unlawful killing, would you not want to argue that no distinction of significance should be drawn between the consequences of a verdict of suicide and a verdict of unlawful killing?
That's precisely our case. If you're against us on that...
So in any event, as my Lord points out, we've really got to grapple with the unlawful killing point, do we not?
Well, the unlawful killing point emerges in some of the authorities we rely upon. So to that extent, yes. But certainly, we do say there isn't a positive case before you which asserts that if you were to conclude that the right test is balance of probabilities for suicide, that the criminal standard ought not to apply in unlawful killing. We say the same standard should apply, that is, beyond reasonable doubt. But to go so far in a case where there's not been full argument and nobody's taking a positive position...
No, well, I can quite understand how you certainly don't want to espouse a case that the civil standard is appropriate for both, but you do argue that the criminal standard is appropriate for both.
Yes.
And therefore, your case does embrace the unlawful killing point, and we, I think, have to at least address the question, why is it the criminal standard in unlawful killing?
Well, I will address that. Yeah. And in fact, as I've indicated, some of the learning in relation to suicide emerges in the cases that address unlawful killing in terms, and the principles that can be extracted from those cases, we say, apply equally in relation to suicide as they do unlawful killing. But I'm mindful of that, my Lord, and I will address that as we go along. My Lord, then, if I can start with the background, the facts, I should say, are, of course, very important indeed for the appellant. However, I can take them very shortly for present purposes without any disrespect to the memory of James, the easiest place to pick the facts up are in the core volume, in the judgment of the Divisional Court, and that is at MS 202. For those using the hard copy, the core volume, Appendix Part 1, page 31. And you'll see at paragraph 2 that the facts are summarised there. Mr. Maughan, James, was a serving prisoner, as your lordships and your ladyship will have picked up, and he was found in his prison cell and confirmed dead.
Yes, you can take it we've read
I'm grateful.
this material.
And you will have seen then there was a 4-day hearing. The coroner withdrew a short form of suicide, but allowed a narrative containing the elements, we say, of suicide, but on the balance of probabilities. Have your lordship seen the questionnaire that was put to the jury and the inquisition?
Well, I haven't.
Let me take you to that then, if I may. This is the second volume, so MS 476, Appendix Part 4, page 305.
Sorry, just give me that page number again, please.
The MS number.
Yes.
The MS number is 476. And this is, in the first instance, the questions that were put to the jury. So, as your lordships and your ladyship may know, it's quite common now to assist a jury in coming to a narrative by asking them to focus on a series of questions.
Yes.
And you'll see at MS 659, before I come to the record of inquest, MS 659, internal numbering 488. Which is a transcript of the coroner's summing up and directions. You'll see at the bottom of 659, that's MS 659, last paragraph, if you have a copy of the record of inquest, and the coroner takes the jury through the parts of the record they're required to complete. And then at the next page, 660, you'll see at the first substantive paragraph, or perhaps it's the second in fact, beginning the next issue, gives them guidance on questions 3 and 4, which together comprise the narrative, as I'll come back to, and says the next issue really is particularly about questions 3 and 4 together. There are 2 ways of approaching a jury's task, or the coroner, if there's no jury, in determining what the conclusion should be. Could be a short form conclusion, natural causes or accident, for example, suicide, or it can be an alternative method of a coroner or jury giving the conclusion, the verdict. We're going to go for the alternative. And then at the penultimate paragraph on that same page, you've heard all the evidence, your findings must be based on evidence, please avoid what might be described as pure speculation. There may not be any wider circumstances or errors or omissions that caused or contributed to James's death. Standard of proof for factual findings to be made on the balance of probabilities, and then points to the questions that have been drafted to assist them. And you'll have seen in the questions back at MS 476 that there are instructions that have been provided under the questions, and they again make clear that the standard of proof is balance of probabilities. And then we see the record of inquest. I'll come to the statutory context for this in due course. MS page number 474, 303 of the internal numbering. And you'll see that there are the name of the deceased and then the medical cause of death. And then at question 3, the how, when and where. And you'll see how, when and where, and investigations where section 5.2 applies in the circumstances in which the deceased came by his death. So there's a wider inquiry in certain cases, and that will apply in prison cases, as I'll come to. And at 3, how, when and where, at approximately 5:20, etc., James Maughan was found hanging in cell C27 at the prison by the OSG, that's the prison officer essentially, making his routine morning roll call. He was pronounced dead at 6:20 on that day by ambulance staff. We believe James deliberately tied a ligature made of a sheet around his neck and suspended himself from the bed frame. So there was a deliberate tying of the ligature around his neck. And then 4, conclusions. James Maughan had a history of mental health challenges, and on the night of 10th of July, James was visibly agitated. We find on balance of probabilities, it's more likely than not that James intended to fatally hang himself that night. So we say that's a conclusion of suicide, albeit in a longer form than the short form of suicide would have conveyed.
A prosaic question, is this document filled out by the foreman of the jury or?
Yes.
Assessing?
It's filled out by the jury. One assumes the foreman, but somebody on the jury will have filled it in.
Written it out, yes, I see.
Written it out, yeah. And then in practice, what happens is it's handed to the coroner before everybody goes back into court to make sure there aren't any obvious errors or the jury haven't gone beyond their mandate, and then it's signed. And the second part of the narrative, which I needn't trouble you with, concerns the question whether or not there were any failings in his care. That's a second point.
If they'd not found that on the balance of probabilities, that it was more likely than not that he intended fatally to hang himself that night, if instead they'd left that bit blank, would they have gone on, could they have gone on to deal with the points which they did go on to address?
Yes, they would have to come to a conclusion in relation to the cause of death, the broader cause of death, the how, when and where, and indeed in what circumstances. If they simply could not make a finding on that, that is whether he intended to, for example, then in relation to that there would have to be an open conclusion, because of course there's no burden in an inquest context.
I think my question was, I didn't put it very clearly.
Sorry, no, it's my fault. I beg your pardon.
If there was an open conclusion, would they have gone on, could they have gone on in their 2 final paragraphs?
Yes, it seems to me they could, because they would be giving a narrative on the broader issue of in what circumstances, and this, as I'll come to, is an Article 2 inquest, putting it in summary. So in fact, it's very much important for the broader issues to be determined where they can be. My Lord, I don't need to trouble you with how matters proceeded then, save to say that there was a challenge to the conclusion on the basis that there had been a determination or finding of suicide on the balance of probabilities, and it was said by the appellant that that wasn't open to have a finding of suicide in a narrative where that couldn't happen in short form because the evidential basis hadn't been satisfied. That was challenged. It proceeded on the basis that the standard of proof for suicide in a short form in any event was beyond reasonable doubt, and the court took up the question, is the premise of this argument wrong? We think actually the standard is balance of probabilities. So it's been agreed at first instance, but the court raised the matter of their own motion, and it's proceeded in that way since. As then to the legal background, unless I can take you to anything else in relation to the events below, as to the legal background, if I can take you please to the core volume of authorities. Firstly, tab 1, which is MS 809. MS 809, which is Authorities Bundle 1. This is the Coroners and Justice Act 2009, which now, along with some rules and regulations, govern inquests.
Now, the version you've given us here doesn't have the preamble,
No.
but I think the preamble makes it clear that this was meant to be new legislation rather than a repetition of what had come before. Oh no, I'm misremembering. It's not the preamble; it's the explanatory note to 2013 rules that I'm thinking about, which we're going to come to later.
Yeah. Certainly, it is new legislation in any event.
Yeah.
And there were significant amendments made to it, one of which I'll come to in a moment.
Yeah. Yeah.
Yeah. So just taking your lordships and your ladyship then, please, to section 1. Duty to investigate in the first instance. So senior coroner who's made aware that the body of a deceased person is within the coroner's area must as soon as practicable conduct an investigation into the person's death if subsection 2 applies, and that applies if, inter alia, subsection 2C, the deceased died while in custody or otherwise in state detention. Section 4 there is the facility to discontinue an investigation where the post-mortem examination indicates that it's not necessary to conduct and to continue with an investigation, but that doesn't apply, as you'll see at subsection 2B, when the deceased died in custody or state detention. So there will always be an investigation when there has been a death in custody. And then turning over, if I may, MS 812. These deal with the matters to be ascertained, and the purpose of an investigation under this part into a person's death is to ascertain who the deceased was, how, when and where the deceased came by his or her death, and then subsection 2, C is the particulars, name and so on, subsection 2, where necessary in order to avoid a breach of any convention rights within the meaning of the Human Rights Act, the purpose mentioned in subsection B, how, when and where, is to be read as including the purpose of ascertaining in what circumstances the deceased came by his or her death. So where, so far as in practice applies, where Article 2 is engaged, and so the investigative obligation is triggered, as it will be in a death in custody, there is an obligation to undertake a wider investigation so the circumstances are explored, as well as the shorter when, where and how. And I'll come to the main Article 2 case because it is relevant to one of the points that may be explored in due course. Next page, so MS 813, there's a duty to conduct an investigation, an inquest. Senior coroner who conducts an investigation under this part into a person's death must hold an inquest into the death, and that's subject to 4.3a, going back to MS 11. Where a senior coroner discontinues an investigation under this section, may not hold an inquest. So you'll have seen discontinuance of the investigation, no inquest thereafter, otherwise a duty to hold an inquest. So where there is a continuing investigation, duty to hold an inquest. And then over the page, MS 814, section 7, an inquest into a death must be held without a jury unless subsection 2 or 3 applies, and subsection 2a, deceased died while in custody or state detention. And then at MS 816, section 10, section 10.2, a determination under subsection 1a, which is the how, when and where and circumstances question, may not be framed in such a way as to appear to determine any question of criminal liability. You'll have seen below that it's suggested, therefore, we don't say otherwise, that the legislature anticipated that criminal liability might otherwise be established, might not determine any question of criminal liability on the part of a named person. So if one finds unlawful killing, for example, one can't identify the name of the alleged killer, although, as I've indicated, and as will be obvious, commonly and perhaps usually that will be obvious. And then B, civil liability. Just for absolute completeness in relation to the Chief Coroner, you'll see at section 35, his role is established and provision is made in Schedule 8, which I don't need to take you to. He's got certain responsibilities to report and the like. And then the next, perhaps more importantly, or certainly more importantly in my submission, MS 818, section 45, rules may be made in accordance with Part 1 of Schedule 1 to the Constitutional Reform Act, which deals with the process in which those rules are made, for regulating practice and procedure at or in connection with inquests, and rules under that section are referred to as coroner's rules. Subsection 2, they may make provision for specific matters, but for my purposes, I simply flag up section 45(1)A, which we say is sufficiently broad to allow for the prescribing of a form, as we see appended to the rules that I'll come to in a moment.
And 2A perhaps is relevant as well, that the rules can make provision about evidence.
Yes. Yes. Yes, my lord. Certainly practice and procedure would be wide enough in any event, but as your lordship said, if there were any doubt about that, then the evidence, power to make rules in relation to evidence would be broad enough in any event. And then dealing with certain matters of procedure, just so your lordships and your ladyship can see how an inquest may play out, MS 820, section 47, goes without saying in an inquest there are no parties, and as I've said, there's no burden of proof, no parties. Instead, there are interested persons, where there are such persons falling within that class. Interested persons mean spouse or sibling, among others. So one may have interested persons status depending on the relationship with the deceased, and then Schedule 1, Paragraph 1, MS 822, there is provision made, MS 822, there's provision made for suspending an investigation where there is a possibility of a criminal prosecution. So a senior coroner must suspend an investigation into a person's death in the following circumstances. Firstly, where a prosecuting authority requests the coroner to suspend the investigation on the grounds that the person may be charged with a homicide offence involving the death of the deceased, or an offence that is alleged to be a related offence I underline. And the next page defines a related offence, so MS 823, which is subsection 6, you'll see that there are some, this is a definitional provision, and towards the end of that provision, you'll see related offence means an offence that involves the death of the deceased, but is not a homicide offence or service equivalent military homicide. And we say that assisted suicide, which I'll come to, might be a related offence. And then finally,
I mean, that's only relevant for this section, is it?
it's only relevant for that section, but it anticipates that there may be circumstances. The only point I take from that is that it recognises that there may be criminal offences that require the suspension of an inquest, and they must be sufficiently serious that they justify the suspension of the investigation at the request of the CPS.
Yeah.
And we say that would embrace not just homicide, but assisted suicide. And then if I may just take you to MS 826, the last on the statutory provisions. This deals with what used to be called prevention of future death reports. A senior coroner may prepare a report where they think it may assist in preventing further deaths. And you'll see paragraph 7.1, senior coroner who's been conducting an investigation, B, anything revealed by the investigation gives rise to a concern, so there's not a requirement to meet any evidential threshold that circumstances creating a risk of other deaths will occur, etc. He can prepare a report and send it off to the person that may be able to address that. The importance of drawing your ladyship's and your lordship's attention to that in particular is that if it be said, well, if we have beyond reasonable doubt, it may constrain a coroner from discharging the obligations under Article 2, which may involve taking steps to ensure that future deaths are prevented, steps are taken to ensure that the preventative obligations under Article 2 are addressed. So making such recommendations, taking such steps to address those matters does not depend upon a conclusion of unlawful killing, suicide, as the case may be. And then if I may take you to the rules, which is MS 827, or the following tab. Rule 9 deals with notification, so a family member is entitled to be notified. Rule 11 deals with the fact that hearings must be in public. And then Rule 13 at MS 831 does allow for disclosure dependent upon what the coroner concludes is relevant. And that is, allows for disclosure to interested persons and others, disclosure of documents at the risk of an interested person.
Sorry, Ms. Maughan, I'm lagging here. Where is the coroner given a discretion to say, I don't think you should have this disclosure?
I think I said that where he considers it relevant.
Yeah, we are quite.
Subject.
Where's that bit?
13(2)(d).
And it's 15.
Yes.
15.
I mean, 13.1 looks absolute. If an interested person asks for it, coroner must provide it. And then 2 is simply including the sort of documents which can be asked for.
Well, if one looks at, as your ladyship's just adverted to, if one looks at Rule 15, that provides a restriction on the extent to which...
Oh, yes, that's it.
So you'll see that C is unreasonable and D is irrelevant.
Thank you.
And then, if I may just take your lordships and your ladyship to MS 835. This is Rule 19. The coroner must allow any interested person who so requests to examine any witness, either in person or by a representative, but must disallow any irrelevant question. And then as to the examination of witnesses, just turning over the page, please, 836, you'll see the order in which examination takes place. It's the coroner first, then the interested person, and then if the witness is represented, the witness is representative. So there is some provision to allow for interested persons' involvement in an inquest through disclosure and the asking of questions after a coroner has asked the questions themselves. MS 837, self-incrimination, Rule 22. No witness is obliged to answer any question tending to incriminate him or her, and a coroner must give a warning, we see that under 22.2, that they may refuse to answer such a question if asked. And then, importantly, my submission at MS 839, Rule 27, no person may address the coroner or the jury as to the facts of who the deceased was and how, when and where the deceased came by his death. So there's no opportunity to make submissions to a coroner in the ordinary way, as one might do in a criminal trial or a civil trial. Of course, a representative, or indeed an interested person, may make representations in the absence of a jury on the legal questions. For example, does the evidence reach the threshold necessary to leave a particular conclusion to the jury, but can't make any submissions on the facts.
Speaking for myself, I'd be very interested to understand why that provision is there.
These are not adversarial proceedings. They are inquisitorial, and that's how they have always been. And I suppose,
well, indeed.
I suppose the answer is they're not adversarial. So there is no opportunity to try and persuade the coroner or a jury that the factual matters they're required to reach conclusions on for one way or another.
Giving somebody a right to cross-examine, but not a right to comment afterwards,
It's not a right.
seems paradoxical.
It's not a right to cross-examine. It's a right to examine.
Okay, a right to examine.
And they are very different proceedings. They're intended to be non-adversarial. In reality, if you've got 5 state parties represented by leading counsel, they can become very adversarial. But certainly the intention is that there is examination, exploratory examination, but not cross-examination, and no opportunity to try and persuade a jury of any matter. So submissions are limited to submissions on the law, it goes without saying, I'm sure, that in making submissions to the coroner in the absence of a jury, of course, one has to address the facts, because if you're assessing whether or not the evidential threshold is met for a suicide conclusion, you have to address the coroner on what the factual basis for such a conclusion would be, or what the evidential basis for such a conclusion would be. But in terms of making submissions on the facts, a closing speech, for example, there's no provision that, well, it's a prohibition. And then, as you'll have seen, at MS 841, Rule 34, importantly, as your lordships and your ladyship will have seen, this deals with the record of inquest. A coroner, or in the case of an inquest heard with a jury, the jury must, and I emphasise must because that represents a change in the position as it had previously been. Prior to the rules, it had been may. It's now a coroner, or in the case of an inquest heard with a jury, the jury must make a determination on and any findings required using Form 2. And Form 2, no doubt you will have seen at MS 846. And that deals with, among other things, the standard of proof. And the facility to come to a conclusion in a short form or a narrative form. As to the Suicide Act...
Just before we leave this, do we have the explanatory notes to the 2009 Act? I was just looking...
I don't have it in the bundle.
No, I mean, the duty to investigate, was that new in this Act as compared to the 1988 Act? I mean, it suggests, I'm just looking online on the explanatory notes, it suggests that that is a new element. And looking at the 1988 Act...
I may be able to assist.
Yes, sorry.
Under the previous legislation was a concept of opening an inquest.
Yes.
The concept of an investigation which could include an inquest was new to the 2009 Act. So the statutory concept of a coronial investigation in those terms was new to the 2009 Act. Before that, it had all the statutory provisions had spoken about opening and then concluding or adjourning and resuming an inquest.
Yeah. So we are interpreting what is in fact a new concept.
Indeed.
What is an investigation, and we're doing so with in mind the Article 2 of the Convention, of course.
Yes.
So to that extent, we've got to be a little careful assuming that all the old cases apply.
Yes.
It might be useful just to have the relevant page.
We will do, and indeed...
Thank you.
We'll get those to you. Just one other statutory provision, if I may, and that's the one relating to suicide. If I can ask you please to turn up MS 1005, which is Volume 2, Tab 14. And you'll see person commits an offence if he does an act capable of encouraging or assisting the suicide or attempted suicide and was intended to encourage or assist a suicide or an attempt, and then certain particular matters concerning it. 1C, the sentence of 14 years. And then over the page, subsection 2, if on the trial of an indictment for murder or manslaughter of a person, it is proved that the deceased person committed suicide and the accused committed an offence under Section 1 in relation to that suicide, the jury may find the accused guilty of the offence under subsection 1. So they may fall to be considered as alternative counts on the same indictment. And I point that out because, in our view, that is also indicative of the seriousness of assisting suicide, so falls within the same category of offence as homicide. As to the case law, if I may just take your lordships and your ladyship to one Article 2 case, again, this is to establish that a beyond reasonable doubt threshold for a conclusion doesn't undermine the investigative obligation in Article 2. There is scope for undertaking the investigation in many ways and discharging the obligation. So MS 908, which is Volume 1 of the Authorities, Tab 6. This is Middleton, which your lordships and your ladyship may be familiar with. Another hanging in a prison cell, many of them regrettably. And if I can ask you please to turn up MS 917, I should say as well that Middleton was the basis of the change in the statutory provisions requiring the broadest circumstances to be considered in an Article 2 inquest. So MS 917, paragraph 3, this is Lord Bingham, the European Court has also interpreted Article 2 as imposing on member states a procedural obligation to initiate an effective public investigation by an independent official body into any death occurring in circumstances in which it appears that one or other of the foregoing substantive obligations has been or may have been violated. That will include where there's been a state failure to protect life or indeed to take life. And then please at MS 918 under paragraph 4, looking at the indented numbers 1, what does the Convention require by way of verdict, judgment, findings or recommendations of a properly conducted official investigation into a death involving or possibly involving a violation of Article 2? 2, does the regime for holding inquests established by the Coroner's Act and rules as hitherto understood and followed in England and Wales meet those requirements of the Convention? If not, can the current regime be revised so to do? So at this point, the findings at an inquest or the conclusions that were required to be reached were only the how, when and where, not the broader circumstances. So that was the position that the Supreme Court were faced with. And then at MS 919, so over the page, the first question, paragraph 6, what, if anything, does the Convention require by way of an investigation? Paragraph 7, European Court has never expressly ruled what the final product of an official investigation to satisfy the procedural requirement should be. This is because the Court applies principles and doesn't lay down rules, because the Court pays close attention to the facts of the case, and because it recognises that different member states seek to discharge their Convention obligations through different institutions and procedures. And then MS 923, if it seems safe to infer that the state's procedural obligation to investigate is unlikely to be met, if it's plausibly alleged that agents of the state have used lethal force without justification, if an effectively unchallengeable decision has been taken not to prosecute, and the fact-finding body can't express its conclusion on whether unjustifiable force has been used, where in such a case an inquest is the instrument by which the state seeks to discharge the investigative obligation. And then 17, does that requirement apply only to the limited cases of justified, prison cases, suicide? The decision in Keenan shows that it's, when I said the Keenan is the prison case, forgive me. So does the requirement only apply where there's been a failure to prosecute? Or does it apply in other cases as well? Keenan shows that it does apply to a broader category of cases, since although in that case no breach was found, the court based its conclusion that Article 13 had been violated that the inquest, which did not permit any determination of liability, did not furnish the applicant with the possibility of establishing the responsibility of the public authorities, and so did not constitute an investigation capable of leading to identification and punishment. So that's the holding in Middleton on the scope of an investigation, what's required by an investigation, and importantly too, paragraph 16 indicates implicitly, if not explicitly, certainly implicitly, that where there has been a criminal trial, so a beyond reasonable doubt threshold, a criminal trial with a proper investigation, there may be no need to conduct an inquest. And paragraph 20, so over the page 924, I don't need to read this to you, but just picking that up again, European courts recognise there are different ways in which the obligation might be discharged. And then MS 927, and just to emphasise where I am at the moment, I've hoped to indicate that the imposing a threshold of beyond reasonable doubt would not in any sense necessarily violate the obligations under Article 2, because as the Supreme Court held, based on European Court authority, a criminal prosecution may be adequate to discharge the duty.
Sorry, where's that?
That is at paragraph 16. The court is saying that if there has been no criminal prosecution and there's plausible evidence or plausible reasons to consider that there may have been a violation of the substantive obligation, an inquest will be required.
Do they deal expressly with the question of standard of proof?
No, I beg your pardon. No, the point I'm making...
You're sort of inferring from...
the point I'm making is if the Article 2 obligation can be discharged in proceedings that set the criminal standard of proof, then if an inquest applies the criminal standard of proof, either to unlawful killing or in our case suicide, that by itself won't violate Article 2. One can impose a beyond reasonable standard threshold and carry out an effective investigation based upon that standard.
Yeah.
To say to a, I'm so sorry,
Sorry, no.
To say to a jury, look, if you think that on the balance of probabilities he committed suicide, we really don't want to hear from you on that. Thank you. So don't answer that question. Wouldn't that be contrary to the basic spirit of Article 2, which means tell us everything that's relevant?
So if I've understood your question, my lord, so if the jury were precluded from making a finding on suicide on the balance of probabilities, yes, one would be left with a position where the Article 2 obligation hadn't been discharged.
Yes, well, yes. That is my question.
Yes, and my answer to that, my lord, is they are entitled to make such a finding if they can find it beyond reasonable doubt, and that is the threshold. If they don't find it on balance of probabilities, one's still left with a no conclusion, be an open conclusion in those circumstances, but there may be circumstances in which whatever the standard of proof is applied, a jury is unable to reach a conclusion. So that by itself in my submission isn't an answer to the question why, whether or not beyond reasonable doubt would deprive the investigation of a meaningful outcome.
Robert, forgive me.
Sure. I was just going to make the observation that the European Court isn't going to lay down a standard of proof.
Yes.
There's a distinction between civil and criminal standards is peculiar to common law systems. So the only issue would be whether there had been an effective investigation or not, and if the imposition of a criminal standard were to be incompatible with holding an effective investigation.
Yes. And in my submission, Lord Bingham, at least implicitly, holds that a criminal investigation, a beyond reasonable doubt threshold, might discharge that obligation, not looking at the European Court authorities at the moment, might discharge that obligation beyond reasonable doubt, so long as there's been a proper criminal trial.
Yes, but it might not. That's the point. It might not. Criminal investigation leading to criminal proceedings might satisfy the requirements of Article 2, but it might not. And in a case where there's no question of criminal proceedings, such as the present, it doesn't really provide the final answer to say, well, a criminal investigation where the proof is beyond reasonable doubt could satisfy Article 2. So if you introduce a universal prescription that it must be proved beyond reasonable doubt for the purposes of an inquest that suicide was what occurred, that at least potentially restricts the opportunity to satisfy the requirements of Article 2.
Well, if there's been a full hearing, my lord, and of course the hearing in public is part of the investigative obligation. It's not just a question of reaching conclusions, it's about airing what's happened in a public hearing. If there has been a full hearing, in my submission, it's not, the outcome, that is the conclusions, are not required if there hasn't been a discharge of a criminal standard, any more than that is the case in an unlawful killing or indeed a criminal trial. It doesn't follow that Article 2 requires something less than beyond reasonable doubt for the duty to be discharged. And that's not a matter of European Court authority. I take your lordship's point, my lord's points, but that's clear from the judgments of Lord Bingham.
Well, one imagines that there might well be authority on this in Strasbourg, in the Article 2 case law. If in a case where there has been a criminal investigation resulting in proceedings in which someone has been acquitted on the criminal standard, and the question may have arisen whether that met the requirements of Article 2. I mean, I don't know without looking up the books what the answer is.
Right, well, we haven't come across any in our researches.
I can remember doing a case as counsel called E and the UK, where it was different in that it was an Article 3, Article 8 case, and the court held that prosecuting a father for abusing his children, or stepfather it may have been, for abusing his children, as a result of which he was acquitted, I think, didn't fulfill the procedural obligations under Article 8 to protect the private lives of the children. But that's a different scenario. But it just sort of indicates one can't take it for granted that the criminal trial will necessarily satisfy investigative requirements.
Mr. Hoff is desperate to tell me that there is a case.
It's not one we've put in the bundle, I'm afraid. There was a case called Bubbins in the United Kingdom, where the European Court held that it was not a breach of the procedural obligation under Article 2, where an inquest had considered unlawful killing and the coroner had withdrawn it from the jury on the basis of evidential sufficiency. The coroner, of course, applying the criminal standard of proof. Mm-hmm. And what the European Court said was, in circumstances where a public official had made a determination that unlawful killing wasn't satisfied or couldn't be satisfied as a matter of evidential sufficiency, it wasn't a breach of Article 2 for it not to have gone to the fact finders, the jury. That may not directly meet the point, but I think it probably provides some assistance.
Well, it'd be useful to have that if we can.
Yeah. We'll get that. We'll add that to our list.
Yes, but there's one thing not to be a breach of Article 2. It's a different thing to address the question, has Article 2 been satisfied? And it seems to me that it can't be the case that every time a criminal trial takes place, that the resources of the state should not be deployed in investigating the circumstances of the death otherwise, because some trials can come to an end because of technical rules, some evidence can be excluded, so it's bound to be the case that it will depend on the circumstances of every case.
Yes.
Yes.
There might be a plea of guilty, for example. There
Yes.
might, for example, be a plea of guilty.
Yes, and I think that's what was guilty. The plea of guilty. Yes, I think, my lord, that's what Lord Bingham is alluding to. The fact is there may be a plea of guilty, in which case there won't have been a public hearing, a testing of the evidence and exploring of what occurred. In those circumstances, there'll need to be an inquest. The simple point I make is in relation to the threshold, the standard of proof. The duty may be discharged, notwithstanding that there is a high standard of proof required. And indeed, there is a case, as Mr. Bunting is reminding me, about circumstances where there was a plea of guilty, I think, wasn't it? A plea of guilty, there needed to be an investigation afterwards in the context of an inquest. We can bring that to you. Yes, it may well have been. But in any event, the short point I seek to extract from this is that the Article 2 duty is not necessarily undermined by setting a high threshold, a high standard of proof.
Yeah. I mean, if you think, for example, of a system like the French system, where the standard of proof, I think, would be une conviction intime, regardless of whether it's civil or criminal. Trying to place that in terms of British standards isn't a very productive exercise. I suspect the Strasbourg court would just accept what the national procedural or evidential rules required.
And this is picked up again, if I may say, in fact, thought I'd come to an end, but paragraph 30, this answers my Lord Lord Kerr's question, or I should say rather than a question, it's observation. Paragraph 30, MS 927, paragraph 29, I should start. How far does the current regime for conducting inquests match up to the investigative obligation? 30, in some cases, the state's procedural obligation may be discharged by criminal proceedings, more likely to be so where a defendant pleads not guilty and there's a trial. So full exploration of the facts. It's unlikely to be the case if he pleads guilty. Or the issue at trial is mental state, because in such cases the wider issues will not be explored. In other cases, short verdicts in the traditional form will enable the jury to express their conclusion on the central issue canvassed at the inquest, so unlawful killing, suicide, as the case may be. Maughan has already been given as an example. Same would be true if the central issue was whether or not the deceased had taken his own life or killed by another. By choosing between verdicts of suicide and unlawful killing, the factual conclusions would be made clear. And then, just to finish off, so your lordships know how we got to the amendments to the statutory scheme, MS 928, MS 928, paragraph 35, the how, when and where is the prescription used in the pre-amendment provisions, or the pre-new provisions. Only one change is, in our opinion, needed to interpret how, in the broader sense previously rejected, namely as meaning not simply by what means, but by what means and in what circumstances. So the Supreme Court, House of Lords, just gave an expansive meaning to how, but we now see that set down in the new legislative regime. My Lord. As to the first of the cases on suicide I'd like to take the court to, that's Braganza, deals with the question of the standard of proof and also particular issues that arise in determining suicide. It's not an inquest case. If I could take you to it, please. It's MS 847, and it's volume 1 of the authorities, tab 3. This wasn't an inquest case, as I've indicated. It was a private law litigation. It concerned a death in service benefit, and there was an exclusion in relation to suicide. The claimant's husband, the deceased, worked on a ship, disappeared. Assumption was that he fell overboard. There was an investigation. Employers' investigators concluded that that was the case, and there was a challenge to that and a consideration of whether or not there should be particular issues in determining whether or not the burden had been discharged, what was the duty on an employer. But in that context, there were observations made in relation to suicide and the standard of proof that in my submission it's helpful to look at. First of all, MS 859. And your 859, and the context, just to remind your lordships and your ladyship, there had been much case law on the question whether or not the standard of proof balance of probabilities was flexible, whether there was some shifting of it, whether it could be movable depending on the severity of the particular allegation. And that was one of the issues that needed to be considered. And at paragraph 33, the judge directed himself in relation to his own decision as to the cause of the disappearance. Before a finding of suicide is made, there must be evidence of sufficient cogency, commensurate with or proportionate to the seriousness of the finding, citing Gray, which I'll come to. Suicide is still a drastic action which often leaves in its wake serious social, economic and other consequences. Also directed himself on Poppy, where 2 improbable causes are suggested, not bound to make a finding one way or another. I agree with Lord Newburger that it's also perfectly proper for the employer to conclude that they've been unable to form an opinion, but the question is how he or she should go about making a positive finding of suicide. And then Lord Justice Longmore pointed out that Gray, which I'm going to come to, might itself be said to be a little outdated, since H and B, which have emphasised in civil cases, there's only one standard of proof, viz. The balance of probabilities. Those cases make it clear there's no sliding scale of probability to be applied, commensurate with the seriousness of the subject matter or the consequences. The only question is whether something's more likely than not to happen. So, mindful of that, if your lordships and your ladyship find that the standard of proof is balance of probabilities, then balance of probabilities it will be. There's no heightened standard. And then over the page at 860, Lady Hale, and this is Lady Hale with whom Lord Kerr agreed, some things are inherently a great deal less likely than others. More unlikely something is, the more cogent must be the evidence required. So there is to that extent, likelihood, but not seriousness, is a matter to take into account in determining whether the burden's been shifted. And at the bottom of paragraph 35, the point I've just made, not the seriousness of the consequences, but the inherent improbability that requires cogent evidence. And then Lord Hodge and Lord Kerr, forgive me, Lord Kerr agreed with Lord Hodge, not Baroness Hale.
Oh, I agreed with both of them.
Oh, both agreed with both. I was going to say, normally you do agree with Baroness Hale.
Oh,
So that's what confused me.
A proper analysis of the cases will not support that sweeping claim.
That was obviously meant lightheartedly.
Well, of course, that was my remark.
And then, if I can, please, I've now lost my page. take your lordships, please, and your ladyship to MS 859 to 60. I've just done that, forgive me. To MS 861, which is the judgment of Lord Hodge, again with whom Lord Kerr agreed. And over the page, makes the point at paragraph 50 that there is an inherent improbability about suicide.
Well, it was inherently improbable in that case. Lord Hodge explains why in the next few sentences.
Paragraph 50, my lord.
Yes.
No history of depression or... that picks up, though, my lord, my submission, the inherent probability, not the seriousness question. But I see your lordship's point.
Well, the only point I was making was that he wasn't saying that suicide is inherently improbable. He was saying that suicide was inherently improbable in that case because the person had no history of depression or mental disorder, and so on and so forth in the rest of the paragraph.
Well, perhaps then Baroness Hill puts it more clearly when she talks with Lord Kerr, with whom...
Was there a majority view in this case?
A majority view.
There seem to be a lot of people agreeing with different people, but...
Well, they all agreed.
We all agreed as to the outcome.
Except for Lord Newburgh and Lord Wilson. Yeah. Lord Wilson may recall.
Anyway, on this point, was there... I mean, the point you get from this is we're talking about improbability, not seriousness.
Yes.
Does that help you or not?
Well, what we say is where it's inherently improbable, cogent evidence, and that's not inconsistent with a beyond reasonable doubt threshold. So although seriousness is not a factor, then in some senses a fortiori a higher standard, because it is serious, it's very serious, could be an alternative charge on account containing alternative count on an indictment containing homicide, and there's no shifting or moving standard of proof in a balance of probabilities assessment.
Miss Maughan, reading your case, I did wonder really where you stood on the shifting balance of probabilities. Maybe you'll come to your paragraph 55 later. You've made the very helpful distinction between seriousness and likelihood. But in paragraph 55, you seemed to elide the two.
I shall come back to that then, my lord.
Thank you.
Thank you for pointing that out.
Could I just ask you whether you would accept that the expression balance of probabilities is not wholly helpful? You underscored the statement about the poppy M. Even on the balance of probabilities, you've still got to get to a certain stage before you can have an affirmative conclusion.
Yes. Yeah. Yes, I mean, it's... and ordinarily, that would be where that wasn't possible, so it would simply be dealt with by determining where the burden lay.
Yeah.
And in an inquest, that obviously that facility isn't there, so we can't make a finding on a balance of probabilities, or indeed beyond reasonable doubt, then it would be open. But yes, there still needs to be a positive finding if a positive conclusion is to be reached, but on a relatively low threshold that doesn't allow for a heightened standard of scrutiny based on seriousness.
It's just that this phrase, balance of probabilities, simply suggests that you weigh up what's there and find which is the stronger, and that's not necessarily the case.
No, if there isn't, and that I think that's also clear here, but in any event, yes, of course, if a court considers that there isn't sufficient evidence to make a finding, even if it's more likely than the converse, determining the outcome will depend on where the burden lies.
Thank you.
And I was going to take you, please, to next to MS 8623. Oh, no, I've just taken you to that, I beg your pardon. And then 865, lastly, just dealing with one point that's been picked up by some of the authorities, and that's the seriousness of a finding of suicide. Further point, I don't rely on it in reaching my decision because it was not argued and it may merit further argument. But I think the employer's obligation of trust and confidence may provide a further reason for requiring cogent evidence. A finding that an employee has committed suicide carries a stigma for the spouse of the deceased employee. And then Mr Justice Tier, in my judgment, cited Lord Justice Watkins, where he stated that suicide is a drastic action which often leaves in its wake serious social and economic and other consequences. So I simply flag that the courts have recognised that. Doesn't go, seriousness of course, doesn't go to heightened standard or need for great cogency of evidence. Nevertheless, we do point out that this is a very serious finding, leaving aside the potential criminal consequences where there is an alleged assistance. There's no doubt that it carries very great stigma and may have very, very serious consequences for a family left behind. My lord, you're looking unconvinced.
Well, I'm sceptical about the extent to which, in current social conditions, there is such a stigma attached. I'm inclined to think myself that attitudes have moved on, but that I may be in a minority on that.
I suspect that's so for some of us, but perhaps not others. And my clients and the family are devout Catholics.
Yes, I understand that. Well, that's rather different. Stigma, at least the way I would use the word, is concerned with how other people see you. And they think worse of you because of something, or the attribute to which stigma attaches. And one can think of some suicides that have been in the headlines recently where I haven't detected overtones of stigma directed towards the person concerned or the family.
Well, that was a celebrity, though, my lord, and there were other factors involved in that. Including having a go at the press. So there were all sorts of other factors. I can't give evidence about stigma, but certainly it's 2015 Braganza, and there is apparent recognition of stigma. Yeah. And in my submission that there is some foundation for that.
Yes,
but I mean, clearly for a, sorry.
Well, as I say, it may be generational as well. There may be different views held by older people from younger people.
I mean, clearly for a devout Catholic, it has a special religious significance, of course. Yeah. But is that something we can take into account in fixing what must be a general test?
Well, it has a specific, I'll answer that, but it has a specific religious significance for oneself and immediate family. But of course, it has a potentially stigmatising impact in the wider community, your community. But to answer your specific question, is that something we can take into account? It's simply an observation, which in my submission strengthens the arguments that I'm seeking to make, that this is a very serious and particular cause of death that might be distinguished from accident, for example. There's no stigma attached to accident, no blame, no resentment, no impact on your insurance, almost certainly. It's a different form of death, and we say it's more analogous to homicide than the other forms.
Well, stigma is not only associated with how the public react to a particular death, but also how the relatives consider themselves or absorb the experience, irrespective of their perception of the reaction of the public. But it may well be, as my Lord says, that is a generational thing, that society generally is more understanding of the forces that drive an individual to take his or her own life, and that therefore the feeling of shame, which I suppose stigma is, should be lessened on that account.
Well, one would hope so, but I suspect, my lords, and again, I don't want to give evidence, and we all have different experiences in life, but I suspect if your child commits suicide, your feelings about that are very different than if they...
It's irrespective of faith. There is still a likelihood that those very closely involved will feel responsible and guilty for not having done that which they could have done to help.
In my submission, it's a very distinct particular form of death, and whether it's stigmatising, whether it causes extra grief to the family, it's very different in character from accident, for example, or indeed natural death.
And I suppose it might depend to some extent on the circumstances. If you have somebody, for example, who is mentally ill, then the reaction is more likely to be one of sympathy and feeling of sadness. If it's, for example, a notorious fraudster who has decided to avoid the consequences of his actions, then people may view that differently.
As I've indicated, it's difficult because our experiences are probably all very different, and it wouldn't be right for me to give evidence. But in my short submission, suicide in my submission is very different in character, not just because of the impact on the family, the stigmatising impact, depending on what your community you're from. I accept that if you're from certain communities, that impact may be very much less significant. But and I suspect very strongly that if it's a child, one could probably live more easily with the fact that they've been knocked over by a bus than come home after school and hung themselves. The next subject I was coming on to, my lords and my lady, concerns the classification of proceedings. And the simple point here is that one doesn't have to be in criminal territory to have a beyond reasonable doubt threshold standard of proof. Now, we know that's so from contempt proceedings, that's the obvious example, but there are other cases which indicate that even in civil proceedings, there may be a beyond reasonable doubt standard applied. And I make that point, I'll come to the cases, but I make the point because it's suggested at times that the nature of inquest proceedings are more analogous to civil proceedings than criminal proceedings. In my submission, that by itself doesn't answer the question because it's not a classification question by itself. So may I take you to a couple of authorities to make that point good? First of all, at MS 1007, which is volume 2, tab 15. This is a case concerning sexual offences orders, which are designed to ensure that sex offenders are kept away from those circumstances where they might cause risk to others. It is a civil process, and if I can ask you please to turn up MS 1016. And this sets MS 1016, forgive me, paragraph 18. And it's necessary to refer to the legislative framework, Crime and Disorder Act, if it appears to a chief officer of police that the conditions are met, namely that the person's a sex offender and reasonable cause, and the person has acted since the relevant date, so as to give reasonable cause to believe that an order under the section is necessary, may apply for an order under the section, under that section. It's made to the magistrate's court, And if it's proved, subsection 3, if the conditions are proved, then a sex offender order may be made, and those are prohibitions that are necessary to protect the public. And then at paragraph 23, looking at the nature of those proceedings, paragraph 23, with that, by way of lengthy preface, I turn to the first issue, which concerns the standard of proof. It's common ground between the parties that Parliament intended an application for a sex offender order in the Magistrates' Court to be a civil proceeding and intended the civil standard to apply. And then at paragraph 31, I'm sorry, MS 1021, I beg your pardon, MS 1021. In a serious case such as the present, the difference between the two standards, balance of probabilities and beyond reasonable doubt, is in truth largely illusory. I've no doubt when deciding whether the condition in section 2.1a, that is being a sex offender, is fulfilled, a magistrate's court should apply a civil standard of proof which for all practical purposes will be indistinguishable from the criminal standard, and if 2.1b is fulfilled, they should apply the civil standard with a strictness appropriate to the seriousness of the matters to be proved. So I appreciate it doesn't go all the way, but it does indicate that the mere classification of proceedings by itself is not determinative of the approach to the standard of proof. And if I can take you to...
I mean, that emphasis on seriousness seems to go against what we were looking at in the later authority.
At the moment, I'm dealing with classification. I'm doing my best to ensure that your lordships have all the assistance.
I'm not complaining, I'm just observing.
Yes.
31 follows from 30. 30 recites Hornell and Khawaja. Well, we all know what they say. And we all know what was later said about that. Yes. And we all know what you said 5 minutes ago about it.
Yes.
So, I mean, this may be a special case, and it may be an entirely correct decision, but I don't think it can be pinned on the seriousness.
No, but the point I'm making here is that the classification of the proceedings is not necessarily determinative of the approach to the standard of proof. And if I can just take you...
Well, you've got a long and very comprehensive list in paragraph 45 of your case, Ms. Manor.
I think that concerns the question what standard is applied in inquests.
The quasi-criminal cases include.
The quasi-criminal cases, yes.
And we've got to number 1, and you've got a whole lot more, and it's all very convincing.
And I'm not going to take you to them all, but may I just take you to one more, if you'll indulge me, just one.
Do.
And that is, because it's a House of Lords case in part, it's MS 1827.
I see, incidentally, that what you've just taken us to, Lord Bingham in B and Avon, is disapproved in Re B, where it's treated, it's taken together with Khawaja as confusing and clarity and certainty is said to have been restored in a later case by the Court of Appeal. It's we find it in MS 943.
I'm not sure, I beg your pardon, my lord, I'm not sure what you're looking at. Excuse me, I'm sorry, it's my...
No, the passage you took us to a moment ago of Lord Bingham's in B
Yes.
was cited by Lord Hoffman in Re B, the case about the standard of proof for allegations of sexual abuse.
Yes.
And it's treated as a confusing dictum and implicitly disapproved on page MS 943. But you may be going to come to that case.
Well, I wasn't proposing to, but I can take you to it.
No.
I can't take it any further than, in my submission, the classification of the proceedings is not the beginning and end of the story.
Yeah.
And I can't make the point any better than that. And I will take you to one more, if I may. Whether or not it will make the submission better, I don't know, but at least I will have drawn attention, I hope, to all the matters that are important. So this is now MS 1827, and it's volume 5. MS 1827, volume 5, tab 60. These are ASBOs. (2002) case. If I can take you, please, to 1840, MS 1840. Paragraph 6. This deals with the, I won't read them out to you, but this deals with the making of an ASBO, antisocial behaviour order, and the circumstances in which they can be made. The issue arose, what was the nature of these proceedings? Were they civil or criminal? In part to determine whether or not Article 6 applied. And at 1849, MS 1849, paragraph 26, dealing with the nature of the proceedings, Lord Steyn, the view that the proceedings are for an antisocial behaviour order in section 1 are civil is further supported by 2 decisions and deals with B, and then down the page, Goff, football banning order. So, according to Lord Steyn, these proceedings are civil proceedings. And at MS 1852, paragraph 37, this deals with the heightened standard of proof. I appreciate that's gone, my lord. But again, I simply indicate that mere classification of proceedings isn't the beginning and end of the story. And I won't say any, I won't push it further, but it's, as I say, simply to observe that if it be said that, well, these are analogous to civil proceedings rather than criminal proceedings, I'd urge the court not to treat that as conclusive. And if I can take you, please, to Lord Hope, because he's much clearer. It's subject to the same observation, that is, it deals with the heightened standard, but if one looks at the last sentence...
Which paragraph, please?
Sorry?
Which paragraph?
I beg your pardon. It's paragraph 83. And dealing with the fact that a factual finding's got to be made about antisocial behaviour, I'd hold that the standard of proof that ought to be applied to cases about the defendant's conduct is the criminal standard.
Can I ask, the authorities you're taking us to are all concerned with adversarial procedure. I mean, leaving aside the point about the footnote, which we'll no doubt come to, if one were looking at the procedure in an inquest, it's not adversarial, it's inquisitorial.
Yes.
And I wonder if there are authorities on whether whether a particular standard of proof applies at all in inquisitorial proceedings.
Not that I'm aware of, and just thinking on my feet, and probably a very bad idea, it would be difficult to see how a conclusion could be rationally reached without there being any threshold of whether that's probability, likelihood, possibility, some threshold if a finding is to be rational. And if one contrasts it, for example, with the PFD reports, the Prevention of Future Death reports, they're not called that anymore, but I've forgotten what they're called, but those reports where statute says one only has to have a concern, so there doesn't have to be a factual finding at all, less so by reference to a standard of proof. But it would seem difficult to determine how one would find whether or not a conclusion is rational.
Well, most legal systems seem to manage. For example, in a planning inquiry, I wonder if there are rules about the standard that applies.
We can have a look at that over lunch, my lord, and see if we can come up with something. But it's different. I'll think about that over lunch. I mean, as I've indicated, on my feet, it seems there must be something other than arbitrariness or mere speculation or throwing a coin in the air and seeing where it lands. But I shall have a think about that.
I suppose there's an add-on question, which is, would the objection to the sliding scale apply equally if there were no standard of proof in a formal standard of proof crystallised in civil or criminal standards in coronial investigations?
May I think about that over lunch, my lady? Simply again, because I may say something and come back and regret having said it. My lady, that may be one other way of approaching it. No balance of probabilities, no reasonable doubt, but there must be sufficient evidence. Still needs to be a threshold, but it would be capable of being unpicked and determining whether it was rational. Was there any evidence? Was it cogent? And so on. But may I come back to both your lordships and your ladyship's questions over lunch? Presently, of course, there is and has always been a standard of proof established by the case law in relation to inquests and indeed by the form. But there we are. But in relation to just one other point, if I may, picking up on an observation, I think by your Lord, my Lord Reid, we would say because they're inquisitorial and because so few rights are given to an affected person, an interested person, that is more the reason to require a high threshold of proof, whether that's described as a heightened standard, cogent evidence, if there isn't a formal standard, the absence of the ordinary protections in adversarial proceedings here makes the basis for insisting on a high standard, cogent evidence, absence of an explanation otherwise. As I've indicated, if you take murder and manslaughter, leaving aside for the moment suicide, your lordships and the ladyship have asked me to address murder and manslaughter. My submission, it would be a very serious matter indeed to reach a conclusion of murder or manslaughter in relation to a person that's readily identifiable without any of the ordinary protections that one would see even in a civil trial attaching in relation to that conclusion, protecting the person concerned. That, my lords, leaves me with the authorities on inquests. There are many in the printed cases. I don't propose to take you to them all. Some of them simply say the same thing. May I take you, however, to the first case where there is an unequivocal holding that the standard for suicide is beyond reasonable doubt. That's the Evans case, and that's the one that the Court of Appeal in this case overruled. That's at MS 1460. MS 1460, and that's volume 3, tab 37. This was a case where somebody had apparently thrown themselves under a train. The facts don't particularly matter, but they're set out at 1461. He was standing by a train. Train sounded its horn, outstretched hands, and fell or dropped onto the track, as the case may be. And then at MS page 1463, I should say this is a divisional court, so it's a first instance, but it's a substantive court, important court, deals with the standard of proof, notes at 1464 that it's no longer a crime, but notwithstanding that, the penultimate paragraph concludes that the balance of probabilities is not enough.
Well, that's conclusion. What about the reasoning?
The reasoning's dealt with fairly shortly, but you can it starts at 1463, deals with earlier cases where there had been not an explicit holding of beyond reasonable doubt, but got close to it. In the days when suicide was a crime, and then the observations which you see.
Very well.
That's the first case where there's been, so far as all of those involved in this case have discovered, an unequivocal holding that it's beyond reasonable doubt.
Sorry, I haven't picked up what the reason is for that.
The reasons are, as given in 1463, that suicide shouldn't be presumed. So there's lots of cases prior to this indicating that, that suicide shouldn't be presumed.
That's very obvious, yeah.
Sorry.
That doesn't inform the choice between balance of probabilities and reasonable doubt.
No, and it appears that it had just been assumed for a considerable amount of time that it was beyond reasonable doubt. It's not expressly stated in the previous authorities. It's all been based on mustn't presume, indicating that it's an improbability, and then here they make it explicit. But it does appear that the beyond reasonable doubt threshold had just been applied, and then this case makes that explicit.
Yes.
my lord. The next case that I propose to take you to is Gray, which you'll have seen referred to from time to time, and that's at MS 881, Volume 1, Tab 4. This is an unlawful killing case, but it is important for that, but it's also important for suicide. That's, as I've indicated, MS 881, Volume 1 of the Authorities, Tab 4. This is a death in custody. And if I can ask you, please, to turn up MS 891. MS 891. You'll see just above letter D, again QBD, a divisional court, just above letter D. I turn now to the standard of proof. We heard much argument about this, lack of direct authority on the point. Referred to cases on suicide going back into the last century, all of which emphasise the presumption against suicide and the requirement of rebutting suicide. Suicide was then a crime, no longer is, but still a drastic action which leaves in its wake serious consequences. And then citing Barber, again, no presumption of suicide. And then next to G, be noted that Lord Widgery, Chief Justice, alluded to the stringent test, but without reference to what might be called the conventional standards of proof. I cannot believe, however, that he was regarding proof of suicide as anything other than beyond a reasonable doubt. I so hold that that was and remains the standard. It's unthinkable in my estimation that anything less will do. So it is in respect of a criminal offence. I think it equally unthinkable, if not more so, that a jury should find the Commission, although not identifying the offender, of a criminal offence. And then the other verdicts, balance of probabilities. So we have there both suicide and unlawful killing equated. And we say that's the right approach. Yes? My lord, I thought you were about to ask a question.
No, I'm sorry if I was having an eloquent expression. What Lord Widgery says is quite interesting. He's talking about the importance of the availability of an open verdict, which is a distinction from adversarial proceedings. Mm-hmm. And so it's in that context that what he says about the absence of a presumption of suicide and the need for positive proof of it makes sense. Because in the absence of such proof, you would return an open verdict.
Yes.
So he's thinking in terms of a different framework from ordinary inter partes litigation.
Yes, but he is holding in terms that in determining whether or not a finding or the evidence reaches the threshold so as to avoid an open conclusion, it must be proved beyond reasonable doubt.
Well, he doesn't say that, does he?
He says, it's unthinkable in my estimation that anything less will do.
Oh, were you talking about Lord Justice Watkins in this case?
Sorry.
I was referring to what Lord Widgery was quoted as saying.
Oh, I see, I beg your pardon, in Barber.
Yes.
Yes. Barber does not hold in terms that it's beyond reasonable doubt.
No.
Barber makes the same point as that I've just alluded to in the earlier case, that it mustn't be presumed, it must be proved by evidence, not to find suicide if it can't be proved by evidence, but an open verdict. But Lord Justice Watkins goes on to say I believe that he was regarding proof of suicide as beyond reasonable doubt, and I so hold. And I can't believe that unlawful killing is any less. So, Lord Justice Watkins is perhaps building on that, but in any event, making clear that there must be positive evidence, and that evidence, if it's going to reach a threshold of proof, must establish the fact beyond reasonable doubt.
It would be great if, when we deliver judgments, we could simply say, in my view, the contrary is unthinkable. One has to go rather further than that, doesn't one?
Well, he may not be the only one who's done that, my lord. He's so holding. All
Yes.
I can do is point to the fact
Indeed.
that it's a Lord Justice and he has so held.
Indeed.
And I accept that the reasoning in Barber provides only a context, but not a precedent.
Quite.
If I can take you then, I'm not going to take you to them all, I promise you, but if I can take you to Kendall, because it also makes good one other point. Kendall, or goes to one other point, I should say, is MS 1474, MS 1474, which is volume 3, tab 40. This is another inquest case. This is a drugs case, inhaling Tipex. There are issues about how the conclusion, or at that stage the verdict, should be formulated. But if I can take you please to 1479, 1479, MS 1479, 1479, at the bottom, just next to, just below H, the first such consideration, so the last paragraph on the page, the first such consideration is the application within the coroner's jurisdiction of a clearly established policy of avoiding unnecessary stigma to the memory of the deceased. It's a reflection of this policy that a verdict of suicide will only be entered beyond reasonable doubt, if in truth there's no other possible conclusion. So a beyond reasonable doubt holding.
Oh, well, it's a dictum, isn't it?
A dicta.
Yeah.
I beg your pardon.
This wasn't the case about suicide. It was an overdose.
An overdose, yes. Yes, I'm sorry. I'm sorry, my lord. And if I can take you perhaps to why I in particular took you to this case, 1478. If this deals with the form, the inquisition, and the changes made in relation to the requirements. So you'll see at the top, more relevant still is Rule 60, form set out in Schedule 4 with such modifications as circumstances may require, may be used for the purposes for which they're expressed to be applicable. And form there includes the inquisition. And deals with the notes, which deal with the way in which a conclusion or verdict should be addressed. And then next to F, as Mr. Coughlin for the coroner rightly recognises, even assuming the particular verdict is appropriate, certainly no compulsion to enter it. Rule 60 merely introduces a particular form with which such modifications and circumstances may be used. So I highlight that because there's been a shift and there's been an introduction of a mandatory requirement, which may suggest that was very deliberate rather than just a... That's the only point I wanted to emphasise from that case, my lord. And if I could now take you to the Court of Appeal case, the only Court of Appeal case that's of relevance. I do rely on those other cases in the printed case, but really they just say the same thing in different ways, and they don't take us any further, and they're all divisional court cases. So if I could take you to McKirbin, which is at MS 895, a restraint death, Volume 1, Tab 5, MS 895. This is an unlawful killing.
Sorry, can you give me that again?
Sorry, it's MS 895.
Thank you.
As I've indicated, it's a restraint death, so asphyxiation. And if I can ask you, please, to turn up 899. So you can see the context. This 899, just next to E, this is reminiscent of inquest's submissions, in fact, because this was a case where the family were asking for the civil standard because the family wanted a conclusion of unlawful killing. And that's, I think, the context for inquests, the NGO's submissions. Sometimes family want an unlawful killing conclusion, and the threshold is set high, making it less likely. So there you see the issue. Question whether or not the burden of proof is the right, was the coroner directed the jury on the right standard, that is beyond reasonable doubt. Families say, no, it's the civil standard. Then if I can ask you please to turn to MS 902. At G 902, same issue arose in Gray, and we've already seen that, my lord, where it said by Lord Justice Watkins that standard the same for suicide and unlawful killing. That was the point Your Lordship was just referring to. And then at page 904, MS 904, deals with the outcome. I won't read it out to you. 904, A to D, you'll see unequivocally, beyond reasonable doubt, making it clear that's the same for suicide. Both these cases, we say, build on suicide to the extent one can find an order. It's suicide beyond reasonable doubt, therefore unlawful killing must be. Checking with my junior whether I've missed any important cases, but he's assured me I haven't, so I'm reassured. So my lords, and my lady, those are the only cases I need to take you to. Of course, they're not authoritative in this court, but they demonstrate how coroners' inquests have dealt with the standard of proof over a number of years, and that finds reflection in the notes. I have one case to take you to about the notes, but I would, if the court would permit me, come back to the K&K case. I'm looking at the time because I may well finish before 12 and deprive myself of the K&K, but I trust it's
one. Not before 12, surely.
So before 1, sorry, before
Yes, that would be
I could talk very, very, very slowly, but I suspect I wouldn't be thanked for it. But so I may have to ask your lordships if I could come back to Kale.
Yes, just for a moment. I think we're making such good progress. If Solidity on the case is gone, we could adjourn early and then sit again early. Sure.
Yep. Yeah.
We'll come back at what time? Come back at 2, probably. Give a bit more than the hour. Good idea.
I think what we might do is invite you to address us at the moment on the case that you have, and then adjourn early for the short adjournment and allow you a longer than usual adjournment so that you can consider the authorities that have been drawn to your attention.
I'm very grateful. Thank you.
And you could also, I think, have a look at the explanatory notes, which I read.
Will do. That's they're being printed and they will arrive very shortly. So
Thank you.
we will do that. Thank you. Can I just ask you, please? This deals with the notes point. To look at, please, MS 1791, which is volume 4, tab 58. And this deals with a provision addressing the standard of proof and whether or not that provision was ultra vires because the Enabling Act didn't address it in terms. So if I can ask you please to look at 1795, the context is exclusion hearings in schools. So children being excluded and provision needed to be made, or is made, for panels to be established and the like. And if I can ask you to look at 1795, setting out the provision in the regulations dealing with the standard of proof, where it falls to the head teacher, etc. Appeal panel, last line, decided on a balance of probabilities. And it was said by the appellant that those regulations, so far as they address the standard of proof, were ultra vires. And if I can ask you to please to look at 1796 paragraph 5, 1796 paragraph 5. This was the enabling legislation. Head teacher of a maintained school may exclude a pupil from the school for a fixed period. Regulations shall make provision, if one looks at D, as to the procedure on appeals, and may also make provision in relation to other matters relating to the exercise of powers. The question was whether or not that was a wide enough power to permit the making of rules in relation to the standard of proof. And at paragraph 41, 1808, summarises that background and the submissions. And at paragraph 43, I'm clear that regulation 7AC is intra vires 52.3D, which deals with procedure, as you will have just seen. Appears that Mr. Wolfe says procedure should adopt is limited to practical steps. I do not object to the notion of steps, but I see no reason why they should be qualified by practical and so on. And if one reads the rest of the paragraph, one can see that general provision addressing procedure and so on is broad enough to embrace regulations addressing standard of proof.
Yeah, and the reasoning in the last sentence, one would have thought would apply a fortiori if the enabling provision allowed the making of rules concerning evidence.
Yes, yes. I had focused on procedure, but my lord is that's perhaps, as you've indicated, an even stronger base. So the short point, of course, to be extracted from that is there's no question that the making of the form and the introducing in the form of the standards of proof and making that mandatory is well within the scope of the enabling legislation. My lord, then I just have some really brief submissions, very brief. Really made my submissions as I've gone along, but just simply to emphasise the very long period of time over which this standard is applied. And these are numerous coroners, not a single case, no basis for overturning the requirement for beyond reasonable doubt. These are inquisitorial, few protections for those involved, serious consequences, including potentially criminal action, no specific charges, no indictment, no statement of case, no right to address the court on the facts. That's the same for unlawful killing as it is for suicide. And in my submission, there's no principled basis for making a distinction, given the seriousness of a suicide conclusion. It's wrong in principle, we say, to treat as analogous civil proceedings. These are very different. Made that point. We also rely on the form, as I've indicated, which we say is a compelling context for concluding that what's intended is the criminal standard. And there can be
in the form, that's only in the short form.
Short form, but there can be no principled difference, we say, between a short form and a narrative form. It cannot be that the standard...
I mean, I certainly see the logic of that, but if we're applying the form, we're stuck with the fact that a different standard applies.
Can you have your cake and eat it?
Yes.
Yes, my lord, we say.
Okay.
Because we say that there is specific provision made in relation to suicide, a specific provision. One can't surely anticipate that it could have been intended that would be avoidable in all suicide cases by simply saying, well, we'll call it, he put a ligature around his neck intending to...
I see the logic of it. I'm just trying to understand how we deal with the rule. I mean, you seem to be saying, well, part of it is ultra vires or irrational. Or...
No, it's like a lex specialis in a different context.
Is
there is provision...
hang on a second. I may have missed something. The difference in this context in short form and narrative presumably has some background in the case law, has it?
It principally post Article 2. There were cases pre-Article 2 that contained narrative verdicts, but a narrative verdict in that context would be a sentence. So I've just used suicide as an example. It could be suicide, or it could be tied a ligature around his neck, intending to kill himself.
Whoever drafted this form presumably had the idea that for the purpose of the suicide and unlawful killing, there was some distinction between the short form and the narrative form. And I don't know where he got that from, or she got that from.
Well, it's what we say is that in treating suicide, unlawful killing and so on, that are typically contained within short form conclusions, not necessarily, but typically, and even when they're narrative, are commonly 5 words or 6 words rather than one. Hung himself from a ligature in the cell intending to kill himself. That's not 5, but perhaps 10. It cannot have been intended that could be avoided.
Anyway, there's nothing in the cases that you know of which supports that distinction.
No. But the emphasis on narrative now is, of course, because we're post-Article 2, and so the legislation was amended to allow for a broad consideration of the circumstances which would be typically found in a Article 2 inquest.
There is some discussion in Middleton, isn't there, in Lord Bingham's speech of the inadequacy of a short-form verdict for certain Article 2 purposes.
Yes. And that was the reason, and we looked at that, and of course he said it's possible to read how, when and where, how in a way to ensure conformity with Article 2 by making sure it includes circumstances, and that would be, circumstances would be typically the right place for a narrative, circumstances being the prison officer didn't check on his routine duties and so on. And that was then included, as your lordship saw, within the primary legislation when new legislation was introduced. So 5.2 tells us that circumstances in an Article 2 inquest can now be considered more broadly, and that will usually be in the context of a narrative. So the prison officer didn't come round when he was supposed to at 7 o'clock in the morning, allowing the opportunity for the prisoner to kill himself, and so on.
Are there any explanatory notes to this part of the regulations, you know?
I'll ask Mr. Bunting to find out.
Thank you, sorry.
I'm told by Mr. Bunting there are, but they don't touch upon that, but I will double check over lunch, so we absolutely are clear about that.
I mean, one can see that the narrative conclusion under the form, it can be an addition to the short form conclusion. Yes. So you could bring home a verdict of suicide, for example, which would have to be on proof beyond reasonable doubt. But then you could have a narrative statement explaining how there had been perhaps inadequate supervision or monitoring by the prison staff, for which there would be a balance of probabilities standard.
Yes. So that would be what 5.2 gets at. There would be, so, I mean, the difficulty with this case is they dealt with suicide in the narrative.
Yes.
But they could have said suicide beyond reasonable doubt, assuming that didn't meet that threshold, but suicide beyond reasonable doubt, circumstances being the officers didn't come round, so on.
Yeah, so it may be if the note is treated as effectively legislation telling us what to do, then on a proper interpretation, the problem in this case wasn't so much, the problem started with a failure to understand that what amounts to a verdict of suicide shouldn't form part of a narrative.
That was the issue, of course, at the divisional court. Yeah. The grounds of claim in the divisional court, where you can't put a conclusion of suicide in a narrative on the balance of probabilities. Yeah. It was when they arrived at the court that the judges said, well, hold on a minute here, the premise of the case is wrong. Yeah. My lord,
right. Was that
subject to the questions that you've asked, unless there's anything else I can help you with.
No, that's very helpful. If you're able to get hold of a copy of Benyon, you'll find, I think, the discussion is under reference to the Warnick case.
Thank you. Thank you very much, my lord, and thank you for those.
Well, we'll resume at 2 o'clock.